A buy-sell agreement is a legally binding contract between the owners of a business where they agree on what happens to a partner's shares in the event of life-changing situations that may result in chaos that could potentially ruin the business and bankrupt its owners, assuring the remaining owners that the business will carry on successfully. That's why we have buy-sell agreements. Hi, my name's Tom. I'm a lawyer at the law firm Collateral Base, and if you find this buy-sell agreement video helpful, please give us a like and a subscribe. We'll keep making them if you keep watching them. And if you have any questions for me, not just about businesses, but about the cannabis business, check out my other YouTube channel, Cannabis Legalization News. So what is a buy-sell agreement? The buy-sell agreement is also sometimes called a buyout agreement, a business will, or a business prenup sometimes, colloquially speaking. Comparing a buy-sell agreement with a prenup is the most accurate comparison, really. In a prenup, you can get out of a marriage under certain conditions, and certain things will happen. You can protect your financial operations. A buy-sell agreement offers these same types of rights, with one small difference. Instead of a marriage, this buy-sell agreement can cover all the financial transactions between the business partners, the valuation of the business so that one party can liquidate its ownership interest for closely held businesses, which of course are different than publicly traded. A buy-sell agreement defines your rights when it comes to difficult situations that your business may face. Your partner can get sick or be unable to operate the business, or just a jerk who you don't want to be in business with anymore. In that case, these buy-sell agreements lowers your financial risks of bankruptcy or debt. You can protect yourself by signing one of these agreements, and it will keep your business, it will keep the transition of your business from when you're not in it more smooth. So speaking about two common forms of these types of buy-sell agreements, there's usually a couple. There's cross-purchase agreements or redemption agreements. A cross-purchase agreement happens when the remaining owners decide to purchase the shares or membership interest of the person that is trying to exit. It's important to know the mechanism on these types of things because the way that they run may have time periods, it may have valuation, definitions, and other stuff that you need to pay attention to. A redemption agreement is another form of buy-sell agreement. Now, in this situation, the business entity buys the shares of the business. They redeem it directly from the shareholder or the member, him or herself. With a redemption agreement, the contract limits the ability of the business owners to sell or transfer their ownership stakes in the business. It wouldn't be dilutive of the members' ownership. It may actually be accretive, because if you go from 3 owners to 2, then each would have 50% as opposed to 33. Now, some businesses, they decide on a mix of these types of agreements, and they have custom provisions in how you can buy or sell areas of this, or they might have what they call a tag-along, drag-along clause. The importance of a buy-sell agreement covers most of the financial risks that may occur in the business. Now, how to know if a buy-sell agreement is right for you and your business? If you plan to start a business with a partner, have a buy-sell agreement. That buy-sell agreement may offer protection to both of you in case there's any change in your business perspective. Many life situations are inevitable, and we relied on this kind of contract, usually a will or a trust document, for our own lives. Why aren't we relying on a buy-sell agreement or some type of exit strategy for your business? It is important. Your business partner may get sick. They may die. That's when a buy-sell agreement would come into effect. You don't want that necessarily passing to his estate. You'd prefer to retain the business ownership so that you don't have to have... There's many reasons. Fewer headaches. Let's leave it at that. Here are some potential situations that a buy-sell agreement would help. It would prepare you for personal bankruptcy of one of the owners. That might trigger their right to sell. Business owner's retirement, a disability of one of the owners, an irreparable disagreement between the partners, death of one of the owners. Cross-purchase buy and sell agreements contribute to the rights of a business owner. As a remaining business owner, you can buy the interests of the selling owner. This applies when a selling owner is no longer capable of maintaining their business obligations. Careful drafting of a buy-sell agreement can also eliminate or reduce any potential estate taxes that apply at your death, or maybe other tax benefits. Please discuss with your CFO how to appropriately structure buy-sell agreements to be tax advantaged. So what can you get from a buy-sell agreement? Well, you can get a fair price for your shares. There might be an entire method to calculate what your shares are worth, often by a CFA, so that they can value your small business. And that would agree as to a set price that the other partners or the business, and if it's redeeming it, would have to pay to be able to cash out that equity owner. And it's important that this agreement sets the figure ahead of time, preventing disagreements between your partners about whether or not a buyout is fair or oppressive. And it facilitates the breakup of partnerships. This buy-sell agreement also minimizes the stress that the disintegration of the partnership, and it's having been designed as a legally binding strategy so that there is an exit to the owner or owners of a company if there is an irreconcilable difference and the company is at what they call loggerheads or deadlock. The buy-sell agreement also specifies who is entitled to your stake if you exit. So that prevents owners from fighting over the partnership interest or the membership interest or the shares in case of a closely held corporation that are going to be going back to the company or to whomever is buying them. All of this uncertainty can be avoided with a well-crafted buy-sell agreement. Do you need a buy-sell agreement lawyer? Probably, especially if your business is doing more than $500,000 a year. You don't need to hire one, but you really probably should. And your lawyer, your business lawyer, that is a corporate lawyer that have seen these types of exits before in other clients, they're going to know what to look out for in crafting your buy-sell agreement. Also, make sure to bring your accountant to the table or your CFO so that you can understand the valuation methods that you use. A good buy-sell agreement lawyer can help you draft the buy-sell agreement so it protects both your business partner's interests and your interests. Will you have the right to continue the business? What types of rights will you have to continue the business operations in the case of exit, death, illness of your partner? Is it possible to stay protected and define a new business strategy with this buy-sell agreement? A good buy-sell lawyer can help you craft and improve the right contract that protects you in the case of inevitable circumstances. Now, when should you make this buy-sell agreement? Now, the perfect time to create a buy-sell agreement is right after you do your operating agreement. So right at the beginning, when you start your company, you should already think, how am I going to get out of this company? And then you'd be able to have a wonderful exit strategy built in. Many operating agreements often have integrations of some types of buy-sell agreements. In the case of now, I shouldn't just be using operating agreements. This is for LLCs. But if you wanted to have an S Corp, it would also work. It would just be like in your bylaws or your shareholder agreements. And then they can define the value of the partnership, time periods, whether or not there's a right of first purchase or right of first refusal, in case somebody wants to buy his shares. Some of the members might not want somebody else coming in. All of this stuff can be spelled out in a high-quality buy-sell agreement. And if your company doesn't have one, you should. So if you have any questions, please leave them in the comments. If you like this, you found it valuable, you have more questions about corporation and business ownership and what a business lawyer does, feel free to ask them in the comments. Give us a like, give us a subscribe. It really helps the channel. And if you have any questions about the cannabis industry, check out my other channel, Cannabis Legalization News.